Hello, I'd like to welcome you to Associa's webinar, COVID-19 Considerations for Community Association Boards. I'm Andrew Fortin, and I serve as the Senior Vice President for External Affairs for Associa. I'm also an attorney. I've worked in the community association industry since 2006, both as an executive at Associa and as a leader at the National Office of the Community Associations Institute. Part of my role as an associate is to assist boards in responding to various crises. With me today are three truly excellent community association lawyers. I'm listing them alphabetically because I would be hard pressed to tell you which is my favorite. They're all super impressive. First, we have Donna DiMaggio Berger. Donna is a partner at the Becker Law Firm, and they have a huge presence across Florida. She's a member of the very prestigious College of Community Association Lawyers and is only one of about 190 attorneys in the state of Florida who is certified as a specialist in community association law. She has so many more accomplishments, but I'll leave it here for now and just say hello, Donna.
Hi, Andrew. Thanks for having me.
Next, we have Denise Lash. Denise is the founder of Lash Condo Law in the Greater Toronto area. She is a founding director and past president of the Community Association Institute Canada chapter and is a qualified expert in condominium law in the Ontario courts. She is a really prolific blogger and writer, and she blogs about condo issues on her Lash Condo Law website. Again, I could go on, but let's just say hello, Denise.
Hi, Andrew. Great to be here.
Glad you're here. And finally, we have Sandra Gottlieb. She's joining us this morning or today from California. Sandra is a senior managing partner at SwedelsonGottlieb. She is also a member of the College of Community Association Lawyers and serves on the Community Associations Institute's National Attorneys Committee. She's a CI certified national faculty member, is extremely active across the state of California in various groups that represent homeowners and community associations. She has law offices across the state of California. Sandra, welcome.
Thank you, Andrew. Thank you for allowing me to join this esteemed panel.
Well, we appreciate all of you making time to help serve our mutual clients and give them some important information. The issue of COVID-19 has been dominating the news cycle for the past few weeks. There's a lot of unknowns associated with where this is going to go. But we thought it would be helpful for our clients to put together a webinar to talk about some of these issues. The goal of this webinar is to provide boards with a framework and understanding of their role and how it may impact their community should COVID-19 turn up in their jurisdiction. I know some of our clients are in markets that have already been impacted, and others may or may not see impacts of this as we go forward. That said, just as with a coming severe storm or a potential hurricane, taking time out to assess the situation, understand your role, and develop a framework to respond if needed just makes good sense. So, as the saying goes, an ounce of prevention is worth a pound of cure. Now, before we get into the substance of this, I want to take care of a couple housekeeping matters. Associa is very privileged to serve communities across North America. And it's important to acknowledge that terminology for associations varies across regions, provinces, states, and countries. So just so we're all clear, everybody listening to this is clear, I want to walk through a few terms we're going to use today. First, the term board. When we talk about boards, we're referring to the elected body that is empowered to govern the association. So this would cover strata councils, corporation boards, condo boards, co-op boards, homeowners association boards, and the like. Second, the term association used is to refer to the wide range of common interest or common ownership communities. So that would include your strata developments, condominiums, homeowners associations, high-rise condos, and 55 plus or retirement communities. Now, finally, the term attorney or lawyer is going to be used interchangeably. This is referring to a licensed professional who is able to provide legal advice in any given jurisdiction. So with that, I want to go through some of the topics we'll be covering on today's call. Again, the goal here is to provide boards with a framework and direction when confronted by concerns about COVID-19 in their communities. So the topics we're going to go through today are fiduciary duty, informational resources for boards, board powers in emergencies, access to common areas, cancellation of meetings or events, lessons from the SARS epidemic, the forthcoming US Census and elections and what that means for our associations, notice when you receive notice of an infection in your community or a quarantine, either voluntary or mandated, special considerations for high-rise communities and 55 plus communities, and how to deal with online forums and rumors. Now, one last thing. Attorneys love disclaimers, and it's really important for the folks watching this to understand that the law is very fact-driven. Facts like your governing documents, your state or province, your country, local factors as to whether there's a state of emergency or not in your particular jurisdiction, all these are going to play a role when an attorney is advising you on what you should do. So it's important to understand that the goal of this program is not to provide you with legal advice, but rather to provide you with information that you can use as a framework to respond and engage professionals as your community moves through the current challenges. Nothing in this webinar should be construed as legal advice or as creating an attorney-client relationship between the viewer or any of the presenters. So now that we got that taken care of, let's dive into some of the questions. First, talking about fiduciary duty. I think most boards understand that their duty is to protect and enhance the values of the association. I think that comes up a lot in presentations and in training and those kinds of things. I think it's less clear what role the board or what the role of the board is when facing a public health crisis. What are you guys' thoughts on things boards need to keep in mind as we head into these set of challenges? Sandra, I'll start with you.
So one of the things that we first need to do is look at the association's articles of incorporation, because that's the document that's going to describe whether or not the association has a duty to take action. We're going to look for a phrase that includes these words: to protect, or the purpose is to protect the health and welfare of the residents and owners in that community. If we have that duty, then it's a different set of facts. If we don't have that duty, we want to be very careful not to take on responsibilities and make decisions where others are going to rely to their detriment, thinking, oh, their board of directors is going to take care of that. Because if you accept the obligation of the duty, even though it's not required at law, you're going to have that duty, and then we will have to deal with the potential damage from that. Actions of the board of directors individually or when they're working together collectively can also create that duty. The biggest message that I believe that we can send to our owners and to our residents is protect yourself. Be responsible for your own health and make certain that the association is not involved in selective enforcement. In other words, providing certain protections to some people or a class of people and denying the same protections to other people. Going through this process and meeting the business judgment rules in whatever state or jurisdiction you're from will allow you to make certain you're not going too far in this process.
Sandra, that's really helpful, and I think you hit on a good point, and that is the business judgment rule. And that means that our boards aren't required to be epidemiologists or medical experts, but they are required to act in a reasonable manner and exercise prudence. Let's move to Donna. Donna, what do you have to add to this?
Well, Andrew, I think this is very similar to our hurricane risk down here in Florida. When dealing with storm damage, a board has to take steps to safeguard the real property from damage, but the overarching goal is to minimize loss of life. I can't think of a single client in Florida that does not have at least a basic hurricane plan to protect their community. However, managing a pandemic is uncharted territory. I can imagine moving forward that many of the boards are now going to be prompted to expand their emergency plans to include a medical crisis of the kind we're seeing right now. I agree that boards need to rely on expert guidance and they need to take reasonable measures. A rogue board member deciding that people coming back from cruises should be locked out of their homes, that's not going to help the situation. One other thing that I would add in this particular crisis, and when we're talking about what the board's fiduciary duties are with regard to planning and preparation and disseminating information, is it would be really helpful if you worked on the board relationship. We see all too often in shared ownership communities that we may have fractured boards. We may have dysfunctional boards. This is not the time for your board to be going in separate ways. Try to get together as a board and navigate this uncharted territory. Work with experts. As Sandra said, the business judgment rule comes into play here. You don't want to acquire additional responsibilities that you don't have, but overall, your residents are looking to you as a source of information and as a source of somebody that knows where we're going and where we're headed with this thing.
You know, you bring up a really good point, Donna. And before I hand this off to Denise, I want to emphasize it. Boards, by their very nature, have debate. They should have debate. But this is a really good time for the board to come together and act in unison. You know, hash it out in a meeting, agree to your direction, and go there. Because when you do have one faction doing one thing and another thing, that does create some challenges. And also, this is an opportunity. This is, if there is any event that I've seen that they should touch base with a legal professional to get some guidance, I think this is it. So I'm going to move to Denise. Denise, what are your thoughts here?
Well, you know, this is really dealing with Canada, and in particular the province of Ontario, where we are located. Our legislation, the Condominium Act, specifically provides that there's a duty on the corporation to manage the affairs of the corporation and really to promote the safety and security and welfare of the owners. So what does that mean? Of course, there's no explicit legal obligation on behalf of corporations through their boards in dealing with pandemics. We did have a bit of experience when we went through the whole SARS epidemic, and I guess I'll talk about that a little later. But the questions and the concerns that are being expressed by boards, and this is where the questions are coming up, is can the corporation force owners to self-quarantine in their units or demand information about where they've traveled to? Because this is the information and the concern that these boards have about knowing what to do in their corporations without having that information. But that said, the board can really take a number of measures to mitigate the health risks in condos, short of knowing who has traveled and self-quarantining individuals. And they really do have to take steps to do the minimum, which is really installing the hand sanitizers in high traffic areas or cleaning and disinfecting routine common areas. But also what's key here is the adequate and regular communication between management, the board, residents, and staff, just so that residents know that the board is taking steps. They have to emphasize that the board and management is taking this COVID-19 situation seriously, and that the health and well-being of the residents of what is paramount importance. Because I think that residents need to have that information and know that the board is taking action.
You know, that's great advice from all of you. And I just want to reiterate or kind of pull out the points that I think were consistent across all the comments. The first is we're in uncharted territory. That this is really a circumstance where the board needs to get some, review their documents, make sure they have an understanding of what their powers are and what they should or should not be doing. Because if you step beyond what your authority is, you own it. You know, you create potential liability for yourself. That the boards will be judged by the business judgment rule, and for lay people, that's the board needs to take reasonable action in line with what their duties are as defined by the governing documents. But there's some common sense things that boards can do right now, and that is, you know, maybe stepping up cleaning of common areas, putting sanitation stations around, those kinds of things. But if there's ever been a situation where boards should reach out to their local qualified counsel on what their steps should be beyond that, I think this is it. Would you all agree to that summary?
Absolutely.
Great. Well, thank you. I think that lends itself to the next question, and that is, um, whoops. Let me just advance my slide here. Oh, I went too far. Um, no. Okay. Well, I'm missing a slide, but hey, that is that's the way things go. Boards, this falls under this category as well, but boards' powers are fixed in their governing documents. We just talked about this. But does a declaration of an emergency at a state or local level change any of the obligations of the boards? Donna, what are your thoughts here? Because I know Florida does have some statutory provisions related to this.
Yeah, well, the pertinent shared ownership statutes typically take priority over an association's governing documents. And Sandra touched on this point initially, that some documents actually impose a higher standard of care on the board. If the documents do not address the board's need to safeguard the health, safety, or welfare of its residents at all, chances are your state statute or your province's statutes will. And in the case in Florida, even taking aside emergency powers for a second, we do have language in 718 that imposes a duty of care on a board of directors in a Florida condominium. In Florida, because of our vast experience with hurricanes down here, the legislature several years back did enact emergency powers, and those powers included things such as being able to cancel meetings, being able to deputize other people as assistant officers and directors, being able to tap into reserve funds, being able to specially assess outside the scope of what your governing documents may require. So those were all powers that were passed to assist boards to kind of dig out of a terrible hurricane, of a terrible event. The issue we're looking at down here is whether or not those emergency powers come into play now. I've gotten a lot of calls from clients because Governor DeSantis has declared a state of emergency in Florida. We have several counties, including the one I'm calling you from, Broward County, that has also declared a state of emergency. That does not necessarily mean, however, that the statutory emergency powers come into play, because the way those were drafted really is worded to address an event from which damage occurred. So, this is where you need to reach out to counsel and say, hey, does this apply? I will tell you that moving forward, we're going to be looking to expand those emergency powers, just as I mentioned with the emergency plan. Every time a challenge comes up, it presents an opportunity to further tweak things. So we will be looking in the future to address a medical crisis under those statutory powers, because I think it's warranted.
So right now, at least in your state, the answer is, probably not. We need to stick with what's in the governing documents right now till the situation, and just keep an eye on how this situation evolves, at least for Florida. Do you think that's kind of what?
I would agree, Andrew. I would think that depending on because there's, as I said, there's like 7 or 8 emergency powers that comes into play. Depending on the power that the board wishes to utilize right now, it may or may not fall within the statutory emergency powers. I'll give you the standard attorney answer. It depends.
Well, it goes back to the disclaimer that it depends on the specific facts. You're in a county with a emergency declaration that may change the thing. And again, just underscoring, there are times where reaching out to that licensed professional is really important. This is one of them. If you can't sense that is an underlying message here, you will by the end of this program. Denise, what are your thoughts on board powers? They're generally fixed in the governing documents and bylaws, but how does that come into the state of emergency?
Well, unlike the state of Florida, unfortunately, we haven't had to deal with those kinds of emergency situations. We do have federal, provincial, municipal laws that will impact condominium corporations and will impose additional duties beyond the governing documents. We do have in our provincial government emergency declaration, so it's probably similar to the state of Florida under the Emergency Management and Civil Protection Act. I haven't seen it being used in my lifetime. Maybe it will be, so we're sort of waiting to see. It can deal with a quarantine pandemic situation, and it would impose additional obligation on behalf of boards. What they are, we'll just have to wait and see if it will be used.
Thank you. Sandra.
So we have to remember, I'm from California, and it seems at times that the California State Legislature's sole purpose is to see how they can micromanage homeowners associations and torture our community managers and legal counsel throughout the state. And I say that with levity, but it does appear to be that way at times. Fortunately, there's no express power in any law in California that would change the scope of duty from the governmental obligation to the association. We know that when developers are building out properties, local cities will say, okay, but we're going to approve this through building and safety, but we need to tell you right now that you have to do the trash and you have to pick up these other functions. In fact, we want you to start taking care of the main roadway into the association. So we know our legislature knows how to transfer that power and responsibility and create this duty. And there's nothing here in California that would allow that. We really need to be careful with our rogue boards who actually will mean well in this situation, but we have to be mindful of the fact that, again, you touch it, you own it. If you create the duty where one doesn't exist at law, you're going to be responsible for the failure to be able to really control the outcome. I think it's important, as I said earlier, to make sure we are conveying this is your responsibility to take care of yourself. That said, there are certain things that I do believe that we can and should do. If we have a community that has a lot of common area or any common area where people are going to meet and or congregate, we want to make sure at every possible place there's a hand sanitizer. We want to make sure that there's Clorox wipes or disinfectant wipes throughout the community. And if your community is large enough, we want to make sure your day porters are going around and working on sanitizing the things everybody is touching: door handles, locks, keys, those things, intercom buttons, those things that incidentally are just things that we will do without even thinking about, oh, I can't touch that. And of course, then there's this deadly issue of touching my eye, touching my nose, and now I've exposed myself.
I think you guys bring up some good points here. And I think, there are, if we go back to, the board itself, the governing powers of the board are generally going to be fixed within their, whatever's in the governing documents. And there may be situations where there is a state law or a decree by a state or provincial or local health department that may require the board to take action. So they need to keep an eye on that. But in the interim, there are some common sense, reasonable person things that boards can do. And Sandra, you just hit on those, I think, really well. And that is step up cleaning of common areas, elevator buttons, door handles, intercom switches, have hand sanitizer stations as available placed around the community, and remind folks that the best thing that any of us can do facing the unknowns here is just to pay attention to basic and simple hygiene. Washing our hands, being aware of touching our face. I can't tell you, how aware I am of that issue lately, right? Like, so just, knowing what their powers are, understanding and keeping an eye on state, provincial, municipal, and national decrees from public health agencies, and working through this, and again, having a line to council. I think that's what I took out of this discussion. But this brings us to, I think, a really interesting question. So in addition to being out there and just paying more attention, reminding folks to just practice proper hygiene, we've all seen it on our feeds. If you want to sing happy birthday while you wash your hands, you can sing these 10 other songs. Having cleaning stations around in common areas, paying attention to cleaning door handles more often. But that gets us into more challenging questions. Can the board restrict access to common areas to individuals at risk? Or can the board even prevent residents from accessing their unit or the facility as a whole? Sandra, what are your thoughts on that?
So accessing their unit, you actually just made me gasp. I hope it wasn't too audible. No, we can't actually keep an owner or resident from accessing their unit. But how we deal with this access or control issue requires us to make sure that we treat everyone the same. It's everyone or no one. I attended a board meeting last night, 11 board members in a very large community. And the question was, who are we to be able to take away the rights for somebody to make an individual choice, whether they want to go to the bridge club in a community room? And the answer is, we are the group that has been retained right now by vote to drive this bus. And until this board is no longer driving the bus, they get to make the decisions. And if we are watching county government and governmental notices, and there are instructions to close down facilities to any groups so that we can deal with these health challenges, we're going to comply with that. We're going to say that is going to override my free right to say, I don't care, I want to keep the clubhouse open so I can go play bridge. It is very important to be mindful of the fact that this is a feeding ground for acts of discrimination. We need to make certain that we do not project anything that could be discriminatory on its face because somebody is a certain ethnicity. And I think that's a really important thing for us to be mindful of. And further, do not ask specific questions about whether somebody is sick and what is it. And the reason is because that could be an Americans with Disability Act violation, and we don't need to be inviting liability into the association. Restricting access, and this goes back to your specific question of can we keep somebody from accessing a unit? In California, we need to be really mindful, and I think this applies throughout the United States and presumably Canada, not to raise discriminatory fair housing issues by denying somebody access. And so we just need to, on our checklist of things we're going to do or not do, so we don't further expose the association to any liability. And then I think the final thing is that we need to, because of urgency, we need to designate maybe 1 or 2 board members as a subcommittee who are vested with the power to make decisions for the association. And board resolutions can include based on governmental mandates or recommendations so that we don't lose valuable time in implementing a process to protect the community and therefore the members or residents in that community.
Thank you. Donna, what are your thoughts here?
Well, listen, the stakes are just higher for our 55 and over communities. So I think you have to take that into account when you're asking whether or not a board can restrict access to common areas to individuals at risk. In addition to having not just an elderly population, in many cases, these communities have a high percentage of people with underlying health conditions. And our government has advised that this group should stay off planes and cruises and avoid large gatherings. So why shouldn't the board of a retirement community take heightened action to close certain recreational facilities? I spoke to my mother-in-law yesterday. She lives in a retirement community, and her community has not communicated any sort of change in policies, but her best friend lives in a retirement community nearby, and she said that they have chosen to suspend all of the social gatherings. They have, many of these older communities, one of the selling points is that they have an abundance of recreational facilities and social activities. So they may have up to 15 different committees. They've asked those committees to temporarily suspend meeting until mid-April. They've shut down the clubhouse, and I can tell you my mother-in-law expressed relief that something's being done. It made her feel good that they're doing something, and she was complaining like, why isn't my community doing anything yet? So, I would say even if some residents may grumble about not being able to play bridge in the card room, others are grateful to see that steps are being taken. Now, I have another community that's very similar to the one Sandra reported on. They do not have that demographic. They're an upscale community in Miami-Dade, and they'd like to shut down. The questions I got is, can we shut down all guests, people from having guests? And no, I don't think you can prevent people from having guests visit you in your home. However, If you've chosen to shut down the clubhouse, if you've chosen to shut down the food service, things like that, apply it across the board and you don't have an issue. But one last thing I did want to mention is that, you know, a lot of these communities, a lot of my communities in Miami-Dade have a high percentage of international out-of-state owners where those units are leased. If we start shutting down facilities and recreational facilities and amenities, potentially there could be an impact on those leases. You can have tenants saying, you know, I bought in this community and now I can't use anything. Something to think about on a going forward basis, that perhaps the addendum to these leases should take into account that these facilities can be shut down if need be in the board's determination.
Nice. Denise.
You know, after hearing Sandra and Donna, I'm wondering if I want to change my position.
Well, diversity of opinion is not a bad thing.
Well, it's just that, you know, we have our provincial legislation, which enables us to prohibit persons from entering onto certain parts of the common elements if they're likely to injure another individual. So if we are aware of someone who has a coronavirus, the board could take the position that they have to, you know, stay in their unit for 14 days and they can't use the common areas, and you can open them up to everybody else. But of course, by doing that, you're opening up the corporation to potential human rights issues and discrimination, and I understand that. But I also understand the importance of these residents to be able to use certain facilities. And, you know, even this morning, we're getting questions from our clients, you know, should we close down the gym or not? And, you know, our position is, you know, we're listening to what the you know, Canadian and provincial and municipal governments are saying, and the health officials, and they're saying we're low risk. So do we wait till there is an individual in the condominium corporation that comes down with the virus before deciding whether to close down the amenities or not? And we're not sure how to give our clients guidance on this point. I mean, we think that maybe if there is a case of a virus, like there has been, and you've seen in the news reports, I know, Andrew, you saw that recent incident, what they did is that persons combined to, you know, quarantine in their unit. They shut down the amenities, they cleaned the amenities, got a professional cleaning company in there to disinfect it properly, and now it's open again, and the individuals in their unit. The communication's out there so that if there are people that are high risk, they may want to leave and move in with family members. So leaving it up to the individuals. You know, the situation's different when you're dealing with a gym versus, you know, your annual general meetings. That's when you have the crowds. And the other question is, if you're going to shut down the amenities, for example, looking at the gym, you know, maybe they're short of closing it down, maybe put in certain restrictions or certain numbers that can use the facilities, and having, you know, the sanitizers and disinfectant areas where you can make sure that you use the equipment with, you know, minimal risk. So before we go ahead and start, you know, advising our boards to shut down the facilities, maybe we should look at other factors.
You know, I think out of all the questions we've addressed so far, I think this one really illustrates the point I made at the beginning of the call, is that these decisions and the advice you get from your professionals are going to be very fact driven. You know, if you're in a 55 plus community or retirement community or high rise, you know, the risk that it poses to those residents who are over 55, or people living in very densely organized housing, a reasonable action for the board in that circumstance might be different than a reasonable action for a board in an HOA that has 4-acre lots and is set up as ranches, right? So what I heard common to all of you guys is, first of all, generally boards are not going to have the ability to prevent residents from accessing their facilities. You need to be very careful about how you apply any restrictions to common areas or things like that. Obviously, look at what the local health authorities are advising, talk to your council, and make sure whatever you do is applied equally. And I think this gets into some really difficult decision making, but I think it goes back to, I'm going to bring it up again, the business judgment rule. The boards need to act, they don't need to be experts, but they need to act in a reasonable manner considering the facts that are available to them at the time, right? And, so if I'm in a state that has emergency declaration and two cases of diagnosed cases of COVID-19, that's a different situation than if I'm in a municipality that the municipal health department has issued a social distancing mandate to the folks in those communities. And I hope that the listeners to this can see that kind of contrast there and understand that there's this scale here, and they need to act reasonably and seek the guidance from local health authorities and their council before they put in place some of these things. Would you guys agree to that kind of?
Yes.
I would, and Andrew, if I may, this is Donna. I've been calling high rises stationary cruises, and I say it because they have many of the same components as a cruise ship. You've got shared ductwork, you've got common enclosed areas, and even many of my luxury high rises have food stations in the morning and in the afternoon as part of their amenities. So these boards in particular need to educate their residents about the steps to minimize exposure. And Sandra and Denise have, discussed that, the hand sanitizer station. But there's other things you can do. In these communities that are a high risk, whether it's the 55 and over or the stationary cruises, as I'm calling them, maybe ask your members to voluntarily reduce the number of guests they invite into the community. If there's illegal short-term rental activity taking place, now's the time to work with legal counsel to curb that activity. And, passing rules that shut off the clubhouse, the lounge, the pool, or rec facilities to private parties, we may be at that point right now where that makes sense.
Yeah, and that's, like I said, again, highlighting you're in a county that has declared an emergency. And I think the closer that those guidances from health authorities get to where you are, I think the more urgent it becomes that, I think that's what's going to guide what is a reasonable reaction, right? The closer this gets to you and your community, the more urgent it is to make sure you're acting reasonably with the information you have from local authorities, be they health authorities and your council. Thank you for that illustration. And I think we just addressed this, but let's go into this anyway here, and that is, not cancellation of meetings, events. I got the slides out of order, so I'm not going to have a slide that matches this, and I apologize to our viewers. But what criteria should boards use to determine if they should cancel a meeting or event or restrict access? I mean, I think we just answered that to common areas, but what would you guys, if you were advising your clients, what are the criteria that you would use to start making those decisions? Donna, why don't we start with you, because I think you just answered that question 2 minutes ago.
Well, life goes on. The board must continue to operate and administer the community. They don't have a choice, and a big part of that is holding open meetings. So I would say this, and I'm speaking to you from a county where we're under an emergency. We have a growing number of COVID-19 cases. But before deciding to cancel or postpone meetings, boards should consider if they can successfully use technology to allow their owners to participate in the meeting from the comfort of their homes. I've had this conversation a number of times with clients in the past days, and there's a big difference between postponing a board meeting or postponing an annual meeting and election. It can often be seen if the board is jumping to postpone the annual meeting that they just want to do what? Stay in power. So there's a different set of concerns when we're discussing whether or not an election should be canceled as opposed to a regular board meeting. If we're talking about a board meeting, let's be honest. I can ask my fellow panelists, how well attended are most of our board meetings? Unless we're dealing with a special assessment, it's not that, these are not typically large gatherings at our board meetings. But even for board meetings, you can use technology. There's meeting apps, there's Skype, there's in-house cable channels. In many of my retirement communities, they use those to broadcast the meetings. So before rushing to cancel something, let's see if there's another way that we can, address the situation. With an election, I would be hesitant to cancel an election right now, even under these circumstances, because there's options. We are one of many states that allow online voting in associations. So if I have an association that has an upcoming election and they're trying to consider whether or not to cancel it, I would say try try online voting, see what happens, see if we can roll that out. But there are options, and I think technology is going to be one that boards should definitely look into before saying they need to cancel a meeting.
Thank you. Denise.
Yeah, I totally agree with Donna. Just this morning I got a call from a manager who wanted to know whether they should cancel their AGM. Electronic voting or online voting is new to Ontario, and so we've had that option as of November 2017. So we are encouraging our boards and management to put that in place, because in order to do it, you need to have a bylaw ahead of time. So there are some that are able to do electronic voting right now, and that's what we're advising them. So before we start recommending to our clients to cancel these meetings, I agree that there are ways to minimize the risk to residents. And there are certain things where, we have the registration at meetings and everybody, gets together at a certain time. Well, that's something that can be changed very easily. So you could space out your registration times, throughout the day, so you don't have a large crowd at the registration desk. Also, I guess what's important is where you're holding these meetings. So if you're going to go through with your annual general meeting, where is it held? Is it a large space, which would be better? Can you sort of maintain that social distancing? So there are those kinds of practical steps, like your, refreshments, how you serve them. Are they all packaged? And then, of course, the communication to the residents. So if anybody's ill, or if you have somebody that's high risk, maybe they want to, stay at home, stay in their unit, or vote electronically if they can, which is sort of the best case. In terms of board meetings, our board meetings are limited to just the board members. So, you either have 3, 5, or 7 board members. It's not a big issue, but they do have the ability to do teleconferencing. And so we're also recommending that they proceed that way.
Thank you. Sandra.
So let us not forget, I'm from California. We don't have online voting. Transparency is the key to all life with our California legislatures. And although I also will look for alternatives to hold meetings, and I share Donna's concern about canceling an election, now knowing that this virus can stay active on a surface for at least a week, if not longer, I think of people who are voting, who are touching our double envelope system and our ballot and putting that in the mail or dropping it off. And then somebody on the other side in California, the inspectors of election, have to touch that paper and open it. And I think that we are too far along in this exposure of risk to continue that risk. I'm not saying that I would cancel annual meetings or cancel the vote at this moment, but I certainly would be looking at the alternatives. When we prepare notices for our ballots, we take into consideration the possibility that the vote would have to be extended or the meetings would be adjourned, and maybe we open them up electronically, inviting the membership into here and explain, due to this crisis, we are not going to be having this gathering. Nobody's ballots are going to be invalidated. We're just going to wait until we have approval from the CDC as to being able to engage in large public gatherings. I think it's hard to believe that social space absolutely can be protected, because people interact when they're together, and our best intentions notwithstanding, they could be spreading the virus. Before we engaged in this webinar today, I heard that Sunday night's presidential debate will be proceeding, but without an audience. As far as I'm concerned, that is an alarm for all of us. Sitting next to each other in bench formats is, by governmental mandate and opinions of the entities that are controlling these debates, too close for comfort. And I think that we need to take our guidance from that and say to our boards, look what the rest of the country is doing in response to this. Don't create the duty, but be mindful of the fact that if there's a way to postpone based on the need to protect the health and welfare of our residents, that we engage in that. We are attorneys, and although you were very clear in your disclaimer, Andrew, that we're not providing legal advice today, if I have to pick health and safety over trying to fix a mess after the fact from a legal perspective, I'm going to go with that scenario and believe that I will be able to protect our association clients after the fact based on decisions that are being made now in response to this emergency.
Thank you. I think this topic is very sobering, for lack of a better word. And I think it goes to, I think if there is something that was common to what all of you have said, is it's really being situationally aware, right? What is going on in my community? What are my local health officials are saying? What is prudent for us to do, and what do we have alternatives to do to minimize that exposure? And when in doubt, maybe err on the side of health and safety of your neighbors. I think that is critical. It goes to that facts-based analysis. If I'm in a state that has no current cases, that's a little different. But if my state or my county or my city has something in play, I need to be aware of that as a board member, and then I need to take reasonable steps based on the information I know, with input from my local health department and from my attorney. I think that's my takeaway from this.
Andrew, if I could just make one further statement,
Sure.
just so we have perspective on how fast all of this is changing while we've been on this phone. I just received on this call and proceeding with this webinar that the World Health Organization just declared this a pandemic. So this is changing so quickly, and the stakes are so high that we need to be mindful of those people who are better prepared to provide advice on how we should do and what this should be perceived, and know that the advice we give our clients today literally could change tomorrow.
Well, and that goes to situational awareness, right? Paying attention to what the World Health Organization is saying. That's literally on a global scale. What is our CDC or the Public Health Agency of Canada saying? What is my state or provincial health agency saying? And what's my county or municipality saying, right? I think those inform, we want our boards to make rational decisions based on the facts that they have available, understanding the situation is dynamic, understanding that they have these resources that can inform those decisions, and making sure that it's a rational, fact-driven decision that errs on the side of health and safety. I think that's my takeaway here. And I think I've silenced a group of attorneys. I think that's never happened to me before. So, I want to go to a question that's really specific to Denise. Denise, I know that the Toronto market had to deal with a similar situation with the SARS epidemic a few years back. And SARS was, from what I understand, much more contagious, much more virulent than what we're facing now. Not that I'm not minimizing this, obviously listen to your health officials on this.
Yeah.
But what were the lessons or takeaways from your experience in that, being a resident of the Greater Toronto Area when they had to deal with that?
Yeah, I mean, it was a little bit of a different situation because, as you said it, I mean, it was really quite fatal. And the symptoms were apparent within days. So, here we have this 2-week period in which those symptoms may not be shown. And there are people that are higher risk than others. But really, my comments are really not like I'm, not commenting from a legal point of view, but really just sort of the best lessons that we learned from the SARS outbreak, which, by the way, was in 2002, 2003, which really is to keep calm and carry on. So to remain focused on preventative measures. So, the sort of the basics and advising residents and communicating, but not to feed on the hysteria. And I think we see that here. I'm not downplaying, this is a pandemic, but really we have to remain focused on what we can do within our communities to reduce the risk. And we've got to keep the lines of communication open between our residents and our staff so they're fully informed. And one of the other important points, again, not really a legal kind of statement here, but just what happened during that whole SARS outbreak, it's important to remind those staff, management, residents that these health pandemics are everyone's issue. So not to place blame on a particular group or a particular country, that everybody has to do their part now to contain the outbreak, and it's everybody's responsibility to do so. So there were problems in the past, and we want to avoid those.
Well, and I think you bring up a good point. Just because an illness or a pathogen originates in a particular country or is prevalent in a particular country, I'm thinking about Italy. You know, I was traveling a couple weeks ago, and I remember, 2 weeks ago, Italy had 0 cases. It now has a lot. But that pathogens are not ethnic specific or national origin specific. Just because something originates in a particular part of the world or is prevalent there, doesn't mean that because my uncle or my father-in-law is Italian that I need to shun him. I mean, that creates a whole nother set of issues. And it goes back to what Sandra said earlier and what you just said. This is about personal responsibility and practicing hygiene and following those directives and taking reasonable actions. So thank you for sharing your insights on that. I'm going to pivot to south of the border. I'm going to pivot to the United States for a minute. And right now, as much as many of us want to tune it out or whatever, we have a national election campaign going on, and we have our decennial census, which is very important for how we allocate resources here in the United States. And a lot of times, this means politicians or their representatives knocking on doors or census takers canvassing in communities. And my understanding is you can't deny these folks entry in most cases. So, so Donna, how should people approach this? Because this is going on against this background of this emerging public health challenge.
It really is almost a perfect storm because we're now in the midst of a pandemic. We have the census, and we are in election season. So it has created a challenging set of circumstances. I was asked this question recently, and my answer was, I think it's reasonable to advise people who have a legal right of access, and that could be the census taker. It could also be the process server. Process servers come all the time into these communities, and they have the right to be there, or the politician, that they have to don protective gear. To the point you were just discussing, and I think it's really important, boards and managers have to expect that not everyone in the community is going to see the risk of this pandemic the same way. For some people, it could frighten them because it could be a potential death sentence. They're looking at this, they have underlying health issues, and they see this as possibly a death sentence if they catch this. For other people, they don't even think this is a problem. They think it's manufactured. So boards have to understand when they're dealing, considering the type of protocols and policies, that not everyone is going to see this as the same level of risk. In terms of these people who have a legal right of access to the community, I think 2 things. One, you can come up with protocol to say, look, we need you to don this protective gear if you're going to come into the community. I've also spoken to clients in my retirement communities. They do not want to have the political event in their neighborhood, and for them, they might want to just say no. Even though there's a legal right at this point, they might want to say no. We're going to delay this until later, maybe until the summer. And I think that's not unreasonable for them to, after they look at the risks, that there's a legal right to be here, but we have exigent circumstances, and we're not going to allow it right now.
Excellent. Sandra, what are your thoughts here?
Well, I think that healthcare protection can be required. The question will be if they say, well, I'm here now and I don't have healthcare protection, meaning masks, gloves, etc. Can we require, in order for them to access into our community and go to our residents, residents, that we provide them with the masks and gloves, and that their being on site is subject to their use. I think that we can do that, and I think that we better be prepared to do that if this pandemic is not short-lived. So I think that's the first thing. The second thing is if somebody, a census taker, or we have a political candidate and an event is going on and they are on site and they are ill, everybody has a supervisor. Find out who they are, the supervisors, and say, I need you to send somebody else here because this person is too sick to be in our community. They may not know that. These are all independent contractors throughout the country that are going to be doing these census programs, and there is no way for there to be control over every person that's going to be coming onto associations. So we have to have this social responsibility to say, yeah, this doesn't look right. This person is not well. I can't ask the question about their illness because of ADA concerns, but I can certainly go to somebody above them. And this speaks to the heart of having protocols in place so that we can actually be in a situation where we can take action without having to regroup as a board. And in those protocols, let's say we have on-site voting in an association, and we're going through right now national voting, we should have, if anybody is using their association as a polling place, it is our protocols that will apply, wiping down between each voter, making sure that the voting stations have this social distance to them so people are really protected space-wise. And I think that we really have this obligation to be intelligent, even in the face of our census and our national election.
Well, I appreciate that. And again, it goes back to reasonable precautions based on the situation. So situation awareness, advice from folks, and reasonable steps. It's not unreasonable to ask someone coming into community knocking on doors to wear rubber gloves and a mask if they're available. We're running short of time. This has been a really fascinating discussion. So I want to get to a question that I think is really, really important here. And what if a board has notice of a potentially infected resident or a resident who is been issued a voluntary quarantine directive? How should boards respond to this? I'm going to start with you, Denise.
Okay, well, we've had this experience and we dealt with it, and right now things seem to be stable. But I think, first of all, you want to make sure that you've got the correct information. So when someone provides you with notice, who is that notice coming from, and does that individual really have the virus, or is it some rumor? So you want to substantiate that first. And if that, if that notice is coming from the individual resident themselves, that's fine, or a family member, or maybe the public health department. But the public health department here has their protocol in place. And once it is made known that there is an individual that has it, they will step in because they need to find out who that person was in contact with. They will guide the condominium corporation because they will want to know where that person has been. Once that information is given by the public health department and the guidance is given by them as to what steps to take, and they will provide that guidance, you want to make sure, first off, that the residents are advised. And I think I mentioned this earlier, that there are individuals that may be high risk and they may, once they find out, want to leave and move in with relatives. So that's really important to get that information out there right away. And then, of course, there are staff or management around, and, they need to be protected as well, whether it's, the hand sanitizers again, or the masks, and they need to be given guidance. And then, of course, as we discussed before, now's the time to shut down the amenities. whether you're permanently shutting it down or, until things get better, or whether, you do put the proper cleaning in place, like the incident we had in that other condominium corporation where they've reopened the amenities.
I think those are good points, and I think, you made a really good point here. There's different kinds of notice and different kinds of quarantine, right? So I'll give you an example. A community where they had a resident return from a cruise. The cruise, I don't think, had anybody on there who was diagnosed, but the cruise line sent the person a letter saying, "We advise you to self quarantine for 14 days." And the folks in the community were aware of this. And the person on day 12 of 14 went to the clubhouse and they were exhibiting no symptoms. What the board did in that circumstance, which is kind of what I think you were alluding to, was the board was like, okay, this happened. What do we do? Their reasonable approach to this, which I think was very enlightening, was they called their county health department and they said, okay, here's what you should do. You should you should close the club temporarily, do some cleaning, and let the employees know. And that's the extent of what happened there. But you mentioned there's all these different people and there's different risk levels for different people. So if there's notice from a voluntary notice that, hey, I was in Italy, I feel fine, I'm going to self quarantine, or if it's more critical where there is a medical or government issued quarantine order, that the government entity in most cases will step in and take over that process. So when there's notice there for the board, or when the board becomes aware, I think engaging public health authorities and their counsel becomes even more critical. Sandra, would you kind of agree with where Denise is going with this and the comments I just made?
I agree with all of that. I'd like to add one more comment, and that is, I am looking at this the same way as I look at criminal activity notices in our community or in adjacent communities. And that is, we don't want to take on too much responsibility, because you touch it, you own it. We take the position that associations do not provide security to its residents, even if there's access control guards, locks on doors. We're just in that situation limiting access control to the best humanly possible. But the important thing is to provide notice. We have been advised that there's criminal activity in our community. It's your responsibility to take care of yourself. Here are websites that you can review. We do that now and have for years for criminal activity. I think it's the same procedure should be in place for how we deal with this virus and notice to the community. And this is the same information we started this webinar with. Notice, providing information to residents so that they can best protect themselves. So you say, this is here, we've been advised that there is somebody in our community who may have been exposed to or carrying the virus. Please follow these protocols that are in place, and then just give them the emails.
And I want to be very clear from, you bring up a really good point that, when this notice takes place, from an agent of the association standpoint, we serve the board. The board is the decision maker. So when this happens, or when or if this happens in a community, we are going to look to the board for guidance on this, right? We are going to be like, okay, we will carry out your lawful directives, but you need to talk to your counsel and you need to scope that communication in a proper way, so you're not creating additional liability for the association, for the people who are impacted by this, or for us who are acting on your behalf. And with that, Donna, do you have anything you would like to chime in on this?
I do, because I was itching to say this. So first of all, what is credible notice? Self-reporting is going to be the most credible evidence. If somebody comes back, I had this in the community recently. The direct employee, front desk employee of the association said, I just got off a cruise. It wasn't a cruise that obviously was quarantined, but they self-reported, and our response was, stay home and I recommended that they pay the employee to stay home in lieu of work. This is another issue we haven't touched on, but associations who are employers should consider adding additional PTO time so their employees are not afraid that they have to come to work even when they're ill. And this often happens, that people who do not have sufficient PTO figure that they must go to work because they can't afford not to. So that's one thing. In terms of the notice, I also, like Sandra, I treat this the same way I treat when we learn that there's a sexual predator in the community. That's explosive, inflammatory information. But the same thing is going to happen when you put out notice saying, we've been informed that somebody in the building has been exposed to COVID-19 or maybe has COVID-19. All hell's going to break loose in terms of who is it, where is it. People immediately try to assess their risk. How close am I to this person? Are they on my floor? Are they next door? That's going to happen. You have to be abundantly clear that this information is correct. And I don't like the association to be the one that's giving the notice. So when it's a criminal activity, when it's a sexual predator, I ask local law enforcement to come in and address the community. In this case, and it hasn't happened yet, but in this case, I would recommend that the Department of Health come in and disseminate that information. I just am not entirely comfortable with volunteer board members getting into those kind of conversations, because the follow-up is going to be, who is it? What can we do? Better that the Department of Health come in and have a meeting and discuss this. Maybe you do it on a broadcast channel because you don't want to have everybody in the same room, but that's kind of my position on it.
Yeah, I think it needs to be handled very, in a measured and informed way, right? You all gave a bunch of reasons why you don't want to. You need to communicate this, but it needs to be communicated by people who understand the implications and can communicate it in the best way possible. And that goes to what I said is, when boards will come to us or our employees and say, hey, we got this, you got to go send this notice out right away. My first question, or our first question back to them, have you talked to your legal professional? Have we talked to the health department here? They're going through a situation like this. Reasonable people need guidance by people who are experts, right? We are not experts. My employees are not experts. You guys are good attorneys. You may be experts in community association law, but we're not experts on infectious diseases. So those are great points. The next one, again, we're a little bit over time here. I think we've answered this. Considerations for 55 plus and high-rise communities. We talked about these people. Donna, you and the developing community is not going to like you for this. High-rises as stationary cruises, but high concentrations of people or high concentrations of people at risk. Those boards should already be out there taking some actions to mitigate exposure, right? Like, reminding their residents that they have agency here to wash their hands, avoid large gatherings, and then making sure that there's special attention paid to common areas and the cleaning frequency and sanitizer stations. So I think we've kind of addressed these, but that's an area where we know at this point, even though this is an evolving situation, I think boards are aware that in those types of communities, there may be a higher risk, and there are things they can take right now that are reasonable and within their powers. Any comment or disagreement on that?
Well, I would only add one thing, Andrew. We always have the sense that it's the outside threat coming in. We see that even with security issues. We put up gates and walls and because we always think that the threat's coming from the outside in, and we've spent some time talking about that today. But often it's our people, our residents are going out, they're bringing the threat back with them. And we certainly can't prohibit people, unless the government quarantines the building, we can't prohibit people from going to the store, going to large gatherings, and bringing that back in. For our 55 and over communities, boards may want to consider seeing if they can provide for delivery services or arrange for delivery services to come, so they minimize their residents having to go out into the larger community.
I appreciate that. Anybody else on this one?
So I just want to say that we need, in those larger communities, we need to look at those persons who are providing services to the association as well, and make sure that those entities have protocols in place that they will remove their employees from service if necessary. So just using the example that was just given, we're going to have deliveries coming in. We want to make sure that the entities that we're working with are not allowing their employees to come on site if they're ill. And I think at this moment in time, we need to come up with alternatives. So even in our own law firm, we have found at a very high price, I might add, that there are offsite facilities in a variety of states that will allow for mail to be temporarily redirected and being opened and sending mail. And because we have business that we have to consider is ongoing, but we also need to be mindful in this higher risk community, meaning 55 and better, that we are doing everything we can to continue with our agents running the communities, but also to be affording those additional protections so the people who are providing services themselves are not carriers or ill coming into our community. And for our employees and that are providing services, we need to make certain that we remind them, if you are sick, stay home. This is not rocket science. Stay home. You have sick days. We will worry about your rent later. Let's get protections in place. I think it's extremely important to keep repeating what should be the obvious.
And just for our listeners, we are in week 3 of communicating that to our folks. We have protocols in place. We have restricted travel. We were asking people to self-report if they travel to high-risk areas. We are again and again reminding folks not only just to wash their hands and pay attention to sanitation, but if they are sick, not to come to work. That is something that that all folks are being doing. And I know probably a lot of us, I got an email the other day from the place where I get my haircut talking about the things that they have done. So, we are doing that. We are following those protocols that are being issued. And you bring up some good points. With that, there's the last question before I close this out is many communities have online forums. Nextdoor, Town Square, which is something we're partnered with, Facebook. Should boards be monitoring these sites? Does it create liability for the board or community if a resident is posting rumors or hearsay that a specific resident is sick? Donna, what are your thoughts on that?
Well, I think the board's response is likely to be different depending on whether or not the social media site's controlled by the board or is it controlled by an owner or a group of owners, because there's vast territory between those two. For the board's forums, I would recommend vigilance in terms of commentary posted, but I don't believe there's going to be any liability created on the part of the board if someone other than the board posts inaccurate or harmful information, particularly if the site has the proper disclaimers and rules posted. I do recommend, and I'm glad you brought up this point because I have a lot of clients that do have presence on social media. Boards right now may want to update their disclaimer and their rules on all of their sites to remind posters about those rules. They may even want to expand on that and say that comments about COVID-19 are neither welcome nor permitted. And I do think it's important that the board identifies the communication channels it will use to distribute official information about COVID-19. So that's terribly important. Tell your people where they can expect to get the official information about what's going on, whether that's we're going to send out weekly email blasts, whether we're going to post it on the website. Also, this is where knowing your community comes into such, it's so important to know your community. If you have a community with younger demographics, group text or emails may work best. If you have a retirement community, your in-house cable channel may be your best mode of communication, but people need to know where is the official information I'm going to be getting with regard to this crisis.
Thank you very much on that. Denise, your thoughts?
Yeah, those were sort of my thoughts exactly. There's a lot of fake news going around, and I think that the board and management should be vigilant about monitoring and responding to inaccurate reports, but only with respect to their official sites. So they should not be going on to the owner's sites and dealing with comments that are made there. Starting to do that, it could pose all kinds of issues and potential liability. But it is important if there's inaccurate reports and they're on the corporation's or official site, that be dealt with, whether it's just a general circular to the residents, advising them as to where they should get their information from, and stressing that it should only be from these reliable sources.
Yeah, and you bring up a good point. I think I've alluded to this in my comments throughout this. For me and my family and how we're responding to this and planning for this, I am looking at the World Health Organization, the Public Health Agency of Canada, the CDC, and then my state, provincial, or local municipal health departments. I think one gives you, the higher up you go, you get a global perspective, you get a regional perspective, and then a local perspective, and that's what's informing my process. And I think that's good. And I would not, again, because I'm not a public health expert, and neither are any of us on this call, I would not want to be the person issuing that advice. So that's why I go to those sources, and understand that this is a dynamic situation. It's going to be evolving. It requires me to stay plugged into that evolving situation. Sandra, do you want to bring us in for a landing on this question?
So I think, yes, I do. I think that if you're not on these sites like Nextdoor or any of the other sites that you have mentioned, even including Town Square or Facebook, that you don't start going on now. My biggest concern with those sites is imputing knowledge and therefore liability to other board members. So we know that we have boards that go on in spite of the advice that are given by association legal counsel about the exposure to liability, but they're on the site. And when they see Joe Schmo is infected, that it is as if all the other board members now have that knowledge as well. So if they're on and if they're trolling and if we have this information, we need to have this protocol in place saying, if you know it, you have to relay it to everybody else so we can protect our interests and the interests of the association.
Thank you. I think that's a really good point. I've got up on the screen right now for the folks watching this webinar some links to important sites that are good sources of information on this. These are the experts in the US and the Canada, the world, and then also encouraging folks to look at and be in contact with their state, provincial health departments, their county or municipal health departments, because that's going to be really a good source of information. Just to wrap things up here, I want to add one thing. We use the term pandemic in this call, and that's a term that I think carries a lot of power and not one we hear often, but I really want to make sure that that's qualified. The term pandemic means, and it applies to the geographic spread of a particular pathogen or illness. It doesn't necessarily refer to the lethality of that illness. So I don't want that to be a point that gets people excited. It should get them to pay attention, but that just means that this contagion is very widespread throughout the world, and it's going to be around for a little while. But to sum up, as we go through this, what we'd like, and I think the goal we put this call together for, is this is an evolving situation, and boards are not required to be medical experts, and nor are managers, nor are attorneys, but they are required to act like a reasonable person and approach this in a reasonable way based on the information that's available. And if there is ever a time that the board should engage and have a discussion with qualified counsel as to what they can and cannot do, what they should and should not do, this is it. And as we go through that process, engaging that counsel on steps they take, making sure that they have knowledge, they act in a reasonable way, they're getting advice from qualified counsel, getting advice from state, local, regional, national, and international health organizations. That's the thesis here, people, is that you need to be reasonable, that knowledge and forethought are going to be very important in how you react to this. And as a board, you're going to set the tone for your community, and making sure that you use the framework and the dialogue we provided today to make those decisions and take those actions in the weeks ahead, because this will be constantly evolving. And as of today, it looks like it's going to be with us for a little bit here. So with that, I want to thank Sandra, Denise, and Donna for being with us today. Thank you guys very much. Please check out their bios and their websites. There's a lot of information out there. These are some really awesome attorneys I enjoy working with. And to our clients, I hope this is useful to you in making your decision process and working with your fellow board members to be able to respond to this in a way that serves your community and helps make this situation better. With that, thank you, and everyone have a great day.